Good morning, everyone.
Yep.
I'm Maureen Spagnuolo. I'm the CEO of the Long Island Board of Realtors. And I'd like to thank each and every one of you for joining us today on this important NAR legal update. We are thrilled that Leslie Muko has joined us and agreed to present the legal update for you today. And Leslie is the General Counsel at NAR. Leslie has a strong background in legal affairs and compliance. She began her career as counsel at the Pennsylvania Securities Commission, where she managed cases involving securities fraud and compliance violations. She then moved to North American Securities Administrators Association and served as associate counsel there. Leslie drafted commercial agreements and managed corporate governance matters. After that, Leslie joined Promontory Interfinancial Network as Assistant General Counsel. She drafted and negotiated multi-million-dollar commercial agreements and again ensured compliance. Leslie is working at the National Association of Realtors, like I said, as General Counsel, Vice President of Legal Affairs and Antitrust Compliance. With her extensive experience, Leslie has proven herself as a valuable legal professional that is highly regarded in her field. We welcome you, Leslie, and thank you very much for being here with us today and giving us the update on the NAR legal lawsuit settlement. Leslie, I turn it over to you. Thank you so much.
Thank you, Doreen, for that very nice introduction. Pleasure to be here with you all today. Yes, I'm Leslie Muko, NAR's General Counsel. I've been with NAR for 15 years, so I have lots of experience and history with the organization. And I know this is a very important and obviously timely topic. So I'm really looking forward to giving you an overview of the landscape and perhaps most importantly, helping you understand how we got here and answering some of those frequently asked questions that we're receiving from members just like you all. So my plan for our time together today is to give you a little bit of a history, again, to help you understand how did we get here to the settlement, what are the events that brought us here, and then to help you understand what the settlement agreement is and those most important terms and practice changes that will result as a consequence of this settlement. And then again, answer some of your frequently asked questions about the practice changes and the settlement terms and what they mean from a practical standpoint, and then point you to resources. And I'm going to do that right now because it's just so important. And so I want to highlight facts.realtor. So if you have not been there, you need to go there. That needs to be bookmarked on your browser. That is the source for all the information about the settlement. We are adding resources, updating resources on that site almost on a daily basis. So that really is your most accurate, most up-to-date resource for information about the settlement and where you can likely find an answer to many, if not all of your questions. And we'll go back through that at the end as well. So without further ado, how did we get here? So you may recall that about 5 years ago, there were several class action lawsuits filed against NAR and 4 corporate defendants. There were 2 class action lawsuits filed by home seller plaintiffs who alleged that as a result of various NAR rules and policies, as well as the corporate defendant brokerage practices, that they were forced to pay artificially inflated commissions. Those 2 home seller cases have been referred to as Merle and the Sitzer-Burnett case. The Sitzer-Burnett case was a copycat of the original lawsuit filed, which was Merle, but the Sitzer case filed in Missouri moved forward at a much quicker pace than the Merle case. So the Sitzer case ended up going to trial this past October. Again, it was a class action lawsuit that purported to represent and did represent home sellers in Missouri who had sold a home using one of 4 MLSs located in Missouri. That lawsuit was filed against NAR, Anywhere, formerly Realogy, Berkshire Hathaway Home Services, Remax, and Keller Williams. So again, in this case, the plaintiff's attorneys alleged that real estate commissions were artificially inflated, buyer brokers were being paid too much, and the MLS cooperative compensation rule, along with the corporate defendant's practices, had led to these artificially inflated commissions. Our position in that trial, in that case, was that commissions were and always have been negotiable. We brought a lot of evidence to the courtroom to show the benefits that both sellers and buyers, but specifically sellers here, received as a result of the buyer having a representative in the transaction, and how the various rules and policies at issue, including the MLS cooperative compensation rule, benefited sellers in attracting more buyers, creating a larger buyer pool, and ultimately selling their property on terms that were more favorable to the seller in a quicker amount of time. Despite all of that evidence presented by the defendants, NAR and the corporate defendants, and the lack of evidence really that the plaintiffs shared through that trial, the jury did return a verdict on October 31st of this past year, 2023, and found that the defendants had conspired to follow and enforce the MLS cooperative compensation rule at issue, and that conspiracy led to sellers having to pay artificially inflated prices and more than they otherwise would. The jury awarded staggering damages of $1.78 billion. And because under federal antitrust law, damages are trebled, that amount would have been tripled had it come to be an enforceable judgment. So that is the background of kind of how we got to this settlement. So throughout the case, when it was first filed in 2019, NAR had always been and was always open to resolving the litigation in a way that fulfilled two very important goals. Number one, to preserve the option for consumers, buyers and sellers to benefit from the cooperative nature of real estate and cooperation amongst real estate professionals, and very specifically that offer of compensation, as well as reduce and protect as many members as we could as a result of these claims. So once we had that jury verdict back in October, we really redoubled those efforts to try to resolve the litigation with those two goals in mind. And so that is really what led to the settlement agreement. Now, if you have heard these legal updates previously, you likely heard how NAR had always planned to and continued to pursue an appeal in the Sitzer-Burnett case. And that definitely was an option, but there was something very important happening between the time that the jury returned its verdict and the settlement. And that is that there were a number of copycat lawsuits being filed across the country, naming hundreds of various individuals and entities in those cases. So there was just a lot of risk. There was a lot of uncertainty. And quite frankly, many of the entities and individuals that were named in these copycat lawsuits would have been forced out of business had they had to defend these cases. And there were more than 20 of these cases filed, and they would have just continued. So we explored, as I said, appealing the verdict, which is something that we were pursuing while at the same time trying to find a more global resolution. But had we pursued the appeal and won, that would only have addressed the Sitzer-Burnett case. It would not have addressed any of the other copycat cases. It wouldn't have addressed the other class action lawsuit that I mentioned that was originally filed in Merle. And it may have only resulted in a new jury trial, meaning that we would have been back in Kansas City in front of another jury retrying the case. And in the meantime, members would have been left with that continued uncertainty and risk. And so would, frankly, consumers. There would have been that continued uncertainty in the marketplace for many, many, many more months, if not years. The other option NAR pursued and you may have heard mention of, is filing for Chapter 11 bankruptcy reorganization. And here, if NAR had pursued that avenue, we would have been able to eliminate our own liabilities, but we would not have been able to address the continued liability for associations, MLSs, and members that they were experiencing as a result of these copycat lawsuits and a result of that verdict. And so it would have protected potentially NAR and paused the litigation against NAR and resolved some of our liabilities, but it would not have addressed the more global risk being presented to our members and the realtor organization. So ultimately, we believed that this settlement and the right settlement was worth reaching. And this settlement ends the litigation of claims brought by these home sellers against these various entities related to buyer broker commissions. So that is very important. It settles it not only in Missouri, but it settles it nationwide and resolves and releases the claims by all home sellers related to these issues in the Sitzer Burnett case. So this was really what we believe was the best outcome that we could achieve in these circumstances. And I can attest to the fact that the decision to settle was not taken lightly. We considered a variety and a diversity of perspectives and opinions from a variety of stakeholders as we pursued these various options and tried to figure out what the best path forward was. So that's really important. And so ultimately, we fought very hard to protect all industry players as best we could. So as you see here on the slide, it's titled Proposed Settlement Agreement. And so I want to hit that point, which is that it is a proposed settlement agreement. In class action lawsuit, ultimately, the court will need to approve the settlement agreement. So the settlement agreement was announced on March 15th. It's a proposed settlement agreement, meaning that we have reached this agreement with the plaintiffs and NAR, and it is now subject and going through that court approval process, which I'll go into here in just a few minutes as to like the process as to where we are and where we're going with that approval. But I'll just highlight here that we have received preliminary approval of the settlement. So that is a very, very important milestone in the litigation. And we have every belief that the settlement agreement will ultimately be approved in November when we are back in front of the judge in Kansas City for final approval. But let's hit some of the key settlement terms so you all can understand what is the settlement, what does it mean to me, what does it mean to the realtor organization, and what does it mean for consumers and the practice changes that will result out of this settlement. So these are kind of the 5 key buckets that I'm going to go through. What is the release of liability, which I've talked about a little bit here. The practice changes related to offers of compensation, written agreements. What is the settlement payment that NAR is on the hook for? And then what does this mean with respect to NAR's admission of guilt or liability, which, as you can see here, we continue to deny any wrongdoing related to the claims or the policies and rules at issue. Okay, so first, the release of liability. So this settlement agreement, if and when approved, would resolve nationwide litigation and claims brought by home sellers related to buyer broker commissions. And this was a very critical and key component of the settlement agreement because it releases most NAR members and many industry stakeholders from liability in these matters. So for example, and very specifically, it resolves claims against NAR. It resolves claims for 1.4 million or more members individually. It resolves claims against all state, territorial, and local realtor associations. It resolves claims against all association-owned MLSs and all brokerages with an NAR member as a principal that had a residential transaction volume in 2022 of 2 billion or below. So that is an enormous universe of individuals and entities that are released under this settlement. So that's why, I just highlight this as a critical achievement because it brings certainty and eliminates that risk and liability for thousands of entities, as well as a million plus members. We were also able in the agreement to secure a mechanism for the individuals and entities that were not included in the release. So there is the ability for non-wholly owned association MLSs, as well as brokerages that had over $2 billion in residential transaction volume in 2022 to opt into the settlement if they so choose. It is voluntary. But there is an efficient mechanism for those entities to opt into the settlement if they would like to pursue it. So that's the release of liability. And so again, it resolves those claims made by home sellers related to broker commissions. So it's any claims or conduct that was alleged in the Burnett and Sitzer case or could have been alleged. So again, an enormous amount of claims and conduct that is released through the settlement. So let's go into the practice changes. One of the key practice changes and agreements that we made as a result of this settlement is that offers of compensation will be prohibited from being communicated on the MLS. So very specifically, NAR has agreed to put into place a rule that will prohibit offers of compensation on the MLS. This practice change, along with the other practice changes I will highlight, all go into effect on August 17th, 2024. So what does this rule mean? This means that no longer can offers of compensation be communicated on the MLS. The MLS cannot be used as a communication vehicle for those offers. But I want to highlight, and I will likely say this many times in our time together, that offers of compensation can continue. That was another very important aspect of this settlement, that it was very, very important to NAR that we preserve that option for consumers. So offers of compensation can continue. They can continue to be communicated in a variety of different ways. They just cannot be communicated on the MLS. And I'll just highlight here that there are more than 40 states that actually expressly permit the sharing of compensation between real estate professionals that permit offers of compensation in the marketplace. And so that can continue to happen. It just has to happen off the MLS. The next key practice change that I want to highlight here is that NAR has agreed to implement a rule that will require that MLS participants providing services to buyers must enter into a written agreement with that buyer. Again, if you have heard a litigation update related to these cases over the last 5 years, you have heard NAR advocating for the last 5 years, but many years prior to that, for the use of written agreements. And here you just see that this is now going to be part of the MLS participants' obligation when working with a buyer. So the participant in the MLS will have to enter into a written agreement with the buyer prior to touring a home. And that obligation is for all MLS participants. So regardless of whether or not they are a realtor or not a realtor, it is linked to that MLS participation. So it really is an even playing field for all MLS participants and the requirement that they enter into these agreements. So a little bit about the settlement payment. So under the terms of the agreement, NAR has agreed to pay $418 million over the next approximately 4 years. The first payment is not due until after final approval, which is in November. And so we are figuring out from an organizational standpoint how we will pay for that very substantial sum of money and resources. And so the leadership team and the strategic planning committee and the finance committee are all working very hard to figure out where and how we'll make those payments. But I can tell you just here, and I'll highlight that NAR's membership dues for 2024 and 2025 will not change because of this payment. They will remain the same. And then last, and very importantly, and is common in these settlement agreements, NAR has made clear that we deny any wrongdoing in connection with MLS cooperative compensation rule. And we continue to believe in cooperative compensation. As I highlighted just a moment ago, that was a critical aspect of the settlement, that those offers of compensation be preserved as an option and choice for consumers. So going into the release just a little more specifically, and hopefully to answer some of your questions proactively, if you are a realtor, you are covered unless you are associated with Home Services of America, which we know announced their own settlement. So you would be covered under that settlement, or if you are an independent contractor. But if you are an employee of any of these remaining defendants in the other cases that were resolved through this settlement, you would not be covered. But if you are an independent contractor, you would be covered. And as a member, you do not need to do anything in order to take advantage of and receive the benefit of this release. But I should say there is one thing you must do. You must be a member of NAR as of the date of class notice. It doesn't matter for how long you were a member before that. It doesn't matter for how long you're a member after that. But you must be a current active member as of the date of class notice, which we know will be no sooner than August 17th. And so the class notice will go out on or about that date. It will go out no sooner than August 17th. But you must be a member as of that date in order to receive the benefit of this release. And then I mentioned that there is that opt-in mechanism that allows brokerages who exceed that $2 billion threshold to opt into the settlement if they so choose. And then I'll highlight Facts.Realtor here, because on Facts.Realtor, if you are one of those brokerages or entities, there is an appendix that needs to be completed, and there are instructions as well as a fillable appendix on Facts.Realtor for you to learn more information about what you need to do in order to take advantage of that, which is to complete the appendix and choose which option you would like to pursue by the deadline, which is June 18th. So a little bit more about the offers of compensation being prohibited on the MLS. So I've hit that point, which is that you can no longer communicate offers of compensation on the MLS, but you can communicate offers outside of the MLS through other common marketing vehicles, like email, signs, flyers. You can even communicate offers of compensation for your listings. So the listings for which you are the broker. You can advertise the offer of compensation on your website for those listings, even when you're doing that through an IDX feed or using MLS data. The important caveat to that is that you cannot display the offer of compensation for other listings for which you are not the broker, but you can augment that MLS data or the feed to display the offer of compensation on your listings. Also, I want to highlight here that while offers of compensation cannot be communicated on the MLS, seller concessions can continue to be communicated on the MLS. So sellers, sometimes decide and choose to offer a concession to the buyer, for example, for closing costs, and that can continue to be communicated on the MLS. The caveat with that is that the concession cannot be contingent on or limited to the use of or payment to a buyer broker. But it could be for something like closing costs, and then the buyer can choose how and which costs they would like to apply that concession to their costs. This is another slide just highlighting again the written agreement for MLS participants. And when I go through some of the frequently asked questions about this particular practice change, I'll talk in a little more detail about that requirement. So I'm going to skip through some of these and head to what are the next steps. What can you expect in this process? So I've told you that it's a proposed settlement agreement, meaning it's subject to court approval. We did receive that preliminary court approval, which was a very important key milestone for many reasons, because it signifies that the court is granting that preliminary approval. And it also means that the home seller class is temporarily enjoined from filing new cases or pursuing existing cases that relate to the claims in this case. So as a result of that, we have been able to get a stay in these copycat lawsuits. So for NAR specifically, and for many, if not all of the defendants in these copycat lawsuits, they were able to, and we were able to get a stay in that litigation pending the outcome here. So that's very important because, as I said earlier, the cost of defense in pursuing these cases is significant and would have put many of our members out of business if they had to proceed with that litigation. So many of those cases have been stayed with respect to the plaintiffs. So we got court approval, the preliminary approval. And so between now and November, which is when that final court approval hearing will be held, November 26th, it is a few things will happen. First, the class notice will go out. And as I said earlier, that class notice will not go out any sooner than August 17th, but it will go out on or about August 17th. On August 17th, the practice changes that are being implemented as a result of this settlement agreement will take effect. That is the date on which you need to make sure that you are a member whenever that class notice goes out. So it'll be on or about August 17th. And then we will head to November 26th when there's that final hearing. In this interim period, it also is not uncommon. It is common that objectors will make filings with the court to make their objections with respect to the settlement known. So that could include really anyone, and very specifically the Department of Justice, who, as you know, is very interested in these cases and this issue and this rule specifically. What I would highlight here, as you may hear about these objectors coming forward to the court, is that the court is not bound by or obligated to approve or deny the settlement based on these objections. These are points of information that the court will take into consideration in reaching its own conclusion about approval. And the court's job in deciding whether or not this settlement should be approved is it a fair and reasonable settlement for the home seller class? And we, of course, believe that this is a fair and reasonable settlement for the home seller class, and we have every reason, therefore, to believe that the court will approve it. Just side note, you may have heard that the other defendants in the Sitzer Burnett case, Anywhere, Remax, Keller Williams, their settlements were just recently, earlier this month, given final approval by the court. So another good signal that we should expect final approval of ours. So when the class notice goes out, that means that home sellers will begin to be given really specific and targeted notice about these claims. And how do the plaintiffs do that? They do that through a variety of means. So postcards, Google ads, social media ads, radio and TV ads, potentially direct mailings to consumers. And there will be a specific website set up for this management of the class and the settlement. And that will be made available as we get closer to August 17th. So to the extent that you get questions from home sellers, consumers about these cases, you can direct them to the claims administrator at this soon to be or to be announced website. This is a graphic of sort of the timeline. I'm gonna just put it up on the screen and then move along, but this is available on Facts.Realtor. So again, that is your key resource. You can find this updated NAR settlement timeline if you want to know what to expect in the coming months. But this is just a quick snapshot of what that timeline looks like. Again, heading towards November 26th for final approval. So with that, I think that's a good overview of the settlement and the key terms. And so now I want to turn to some of the key questions that we are hearing from members like you and try to hit some of those and see if there are any other questions coming in from the audience. So the first question that we get a lot is, how will buyer brokers get paid now? So as you know, real estate professionals have and will be able to continue, despite this agreement or even in light of this agreement, to make independent decisions about how and what they charge for their services. That remains unchanged with the settlement. As I've said a few times now, but it really bears continuous repeating, offers of compensation continue to be an option. So that continues to be an option for how potentially a buyer broker could be compensated. It just has to be pursued off MLS through negotiation and consultation between real estate professionals and consumers. So buyer brokers could be paid from a variety of different sources or forms, I should say. It could be paid directly by the buyer consumer. It could be paid through a concession from the seller. It could be paid through an offer of compensation by the listing broker. And it can continue to be negotiable throughout the transaction. And so I think I hit on this a little bit earlier, but how will individual brokers be able to advertise their commission and cooperative compensation? So again, that can continue to be advertised. It can be advertised to on your website, as I said, for your own listing. So it very expressly in the settlement agreement allows for the communication and advertisement of offers of compensation on your website for your own listings, just never for other listings for which you are not the listing broker. And it can be done through flyers, email, phone calls. Some of those, I guess I'll say more old fashioned. We have to kind of go back in time as to how we communicate it. But it can be communicated virtually anywhere other than the MLS. So as I said, these practice changes are going to take effect August 17th. So what does that mean for active agreements, whether it's a listing agreement or a buyer agreement that is in existence that sort of transcends that August 17th date? So for listing agreements that are active after August 17th or as of August 17th, they don't necessarily have to be amended, but you'll want to look at that listing agreement and see whether or not it directs that the listing broker will make an offer of compensation on the MLS. If it does, then that would, of course, violate the MLS policy change that takes effect on August 17th. So an amendment may be needed. But if it doesn't specify whether or not that offer of compensation is made on the MLS, then there shouldn't be a reason to amend that agreement. But it also might, just from a practical standpoint, bear a conversation with the seller, letting them know of the change in practice and just confirming that they continue to desire that offer of compensation. But again, if it doesn't specify that that offer of compensation will be made on the MLS, then there's no reason to have to amend it. And then for active buyer agreements, meaning there's no purchase offer that has been accepted, the buyer broker will want to take steps necessary to make sure that the written agreement comports with the requirements of the practice change related to written agreements. And that very specifically requires 4 key elements, which I think I'm going to go into here in a minute. And I will, maybe I'll just, I'm going to skip to that because it kind of correlates to what we're talking about. But what provisions have to be in the written agreement? So what do you need to be looking for when that August 17th date hits? Per the practice change, there's essentially 4 key things that have to be in a written buyer agreement. There has to be a specific and conspicuous disclosure of the amount or rate of compensation that the participant will receive or how that amount will be determined. The amount of compensation has to be objectively ascertainable and it cannot be open-ended. So essentially you need to be able to look at it and say, I understand, I can tell and know how much the consumer has agreed to pay the buyer broker for their services in this transaction. It must include a statement that the participant is prohibited from receiving compensation for their brokerage services from any source that exceeds the amount or rate agreed to in the agreement with the buyer. And then there must be a conspicuous statement that the broker fees and commissions are not set by law and are fully negotiable. So that is all that the practice change requires, those 4 things. There has been confusion about whether or not the practice change requires that there be a written agency agreement. There is no requirement that it be an agency relationship or what type of relationship the professional has with the buyer. So whether that's an agency, non-agency, sub-agency, transactional, et cetera, the practice change does not speak to that. It is a written agreement. It is not a written agency agreement. So I want to make sure that that is understood because there has definitely been confusion about that. Again, NAR policy is not going to dictate the type of relationship, the term of the agreement, the services to be provided, and of course, the compensation to be charged. That is all a matter of discussion and negotiation with the consumer. So digging into the written agreement requirement just a little bit more, what does it mean to be working with a buyer? So the working with the buyer, so sorry, let me just back up a minute. The written agreement has to be entered into when a MLS participant is working with a buyer and prior to that, prior to touring a home. So what does working with a buyer mean? The language is intended to distinguish an MLS participant who provides brokerage services to a buyer, like identifying potential properties, arranging for tours, facilitating negotiations or an offer, from MLS participants who are simply marketing their services or just talking to a buyer. So for example, at an open house, talking to an unrepresented buyer or giving access to a home to an unrepresented buyer would not trigger that requirement because you are really providing services to the seller and not the buyer. So that is what working with the buyer is intended to mean. And so what does touring a home mean? Touring a home is where the buyer and or the MLS participant or another agent at the direction of the MLS participant working with the buyer enters the home. And that includes when they are physically entering the home or providing a live virtual tour to a buyer who is not physically present. So it could be both of the parties are at the tour of the home, or it could be one of the parties are at the tour of a home. And both of those scenarios would trigger the touring a home part of that requirement. And then what does home mean? Home means a residential property consisting of not less than 1 or more than 4 residential dwelling units. This settlement really is about residential real estate. It's not about commercial real estate. And so that's where that term definition comes from. And then I think this is the last FAQ I will answer, and then I'll turn it back over to Doreen to see if there are any other questions that have come in. But because this is a question that we've gotten a lot, which is, what if I am the listing broker showing a property to an unrepresented buyer? Do I need to have an agreement with them or provide any disclosures? And I think I already kind of answered this, but I want to just repeat this, that the intent was not here that the listing agent would need an agreement with the buyer. So if you're a listing agent at a home open house and buyers come in to see the property, you would not be required to have a written agreement with that buyer. They're unrepresented. You're not providing services to them, even though you're making the home available, you're opening the home to them. You're working on behalf of the seller and not the buyer. And so the written agreement requirement would not be triggered. But there is possible that under state law, there's some disclosure that may be required, but there's nothing pursuant to the practice changes. So with that, maybe I'll turn it back to Doreen to see if there are any other questions that have come in that I can try to answer.
Hey, thank you so much, Leslie. We do have a few questions that came in from our members. Here's one of them. How does the new requirement that buyer's agents cannot receive compensation for brokerage services from any source that exceeds the amount or rate agreed to in their written buyer agreement apply to a dual agency situation? So, for example, does the compensation limitation in this new rule apply only to services, compensation for buyer services? Or put another way, in dual agency, is the agent also permitted to receive compensation from the seller for listing services as agreed upon their listing agreement in a dual agency situation?
Okay, so the limitation on what the buyer broker can receive is specific to the buyer broker. It does not address the listing broker. So when we're talking about that compensation limitation, meaning it cannot be more and they cannot receive anything outside of from any other source except what is agreed to in the written agreement with the buyer, that applies to the buyer broker. In a dual agency situation where the agent is acting for both the seller and the buyer, you would look to the respective agreement. So what does the listing agreement say with that seller? And what are you to receive as a result of those services? And then you would look to that written agreement with the buyer and see what they've agreed to with the buyer in terms of compensation. So the agent could theoretically receive compensation from both sources, and that would not be prohibited under the agreement.
Okay, thank you. I have another question. Can the listing agent or the seller demand to see the buyer's agent's written buyer agreement before showing a property? Or can they ask the buyer's agent to sign an attestation that they have a written buyer agreement?
No, they should not ask to see the buyer agreement or demand that the buyer agent sign an attestation or the buyer sign some attestation. That relationship and that agreement is between the buyer representative and the buyer. If there is reason to believe that there is not a written agreement and the MLS participant is not complying with that requirement to have the written agreement, then one option that the MLS participant could exercise is to contact the MLS, because the MLS ultimately will be enforcing that requirement. And that is where they should direct that concern or complaint, but they should not demand that the buyer or buyer agent provide a copy of their agreement.
Another question is, what should a buyer's agent do if the buyer refuses to sign a written buyer agreement?
That's a good question. Not serve them, convince them to sign the agreement. But the practice change requires that if you are working with the buyer and before touring a home with that buyer, that there be a written agreement. And as I highlighted earlier, that requirement is like a level playing field because it applies to all MLS participants, regardless of whether they're realtors or non-realtors. And very simply, you cannot provide services if the buyer is unwilling to enter into that written agreement.
Okay. Leslie, I can't thank you enough for all of the information you've provided to our members, for you taking the time out of your very busy schedule to be here with us today. So thank you very much. Before I actually close, there are just a couple of things I would like to say. This has been recorded, this session, and will be uploaded onto lirealtor.com. Also, please note that on lirealtor.com, under the webinars, under the NAR settlement update section, we also have a webinar that Patrick Fife, our general counsel at LIBOR, did not too long ago, and that if you take a look at that webinar, it will answer many of the other questions that I did see in the chat today. So please take a look at that. Also, again, please go to facts.realtor.com, NAR. If you could even look at it every day, you will be that much better off, because NAR is updating it with so much information and facts and questions, depending on all of these other questions that our members are bringing forth. And also check our website, lirealtor.com, regularly for the most up-to-date information too. And I assure you that we are working diligently behind the scenes to update all of our forms to be in compliance with the new NAR rules and regulations. Leslie, again, thank you so much, and we appreciate all that you do for us.
Thank you, Doreen, and thank you all for attending and listening, and Facts at Realtor.
Thanks.
All right.
Goodbye.
Have a great day. Bye-bye.